Hi, I am Ashutosh and me along with my teammates Sahil, Sukanya and Ayushi from National Law University Jodhpur, India have worked on a project called Analyzing India's Steel Trade under its FTAs with ASEAN, Japan and Korea. And for this project we have focused on the product code HS72. This project is important because India is now the second largest crude steel producer in the world and the Indian steel industry is huge. It contributes around 2% to the Indian GDP. But the Indian think tank Niti Aayog and the government data and reports show that the Indian steel industry has not benefited from these FTAs. And to understand why, we first analyzed tariff measures. As you can see, pre-FTAs, the Indian tariffs were pretty high, around 15% compared to Japan and Korea, which are closer to 3%, which were dropped down to close to zero. So, the Indian exporters did not benefit much, but there was a surge in the import of steel products which was not favorable to the Indian steel industry and consequently damaging it.
In the second part of our project, we deal with non-tariff barriers. Non-tariff barriers can be defined as any policy measures other than tariffs which can impact trade flows. Our research on the measures imposed by the target countries shows that most of the target countries had imposed some kind of technical regulation or standards for various reasons, such as consumer protection, ensuring the quality of steel, etc. Based on our analysis, we found out that entering into mutual recognition agreements or MRAs is the most suitable option for us to facilitate the acceptance by one party of the results of the conformity assessment procedures undertaken by the other party's conformity assessment body. Such agreements would lead to a reduction in cost as well as a reduction in time in the trade of steel. The third part of our analysis focuses upon customs and trade facilitation procedures. An analysis of provisions of custom and trade facilitation procedures in the FTAs brings out 4 points of concern. The first being use of soft language such as must endeavor to or must work towards, which cannot be enforced under the FTAs. The second is a lack of subcommittee for customs procedure in FTA with ASEAN. The third is a lack of a point of contact from where all information can be provided or where concerns may be raised in FTAs with Japan as well as ASEAN. And the fourth is a lack of a comprehensive provision dealing with publication of relevant information, especially online, in any of these FTAs. Based on these concerns, we have recommended various measures in our project.
The fourth part of our analysis deals with rules of origin. Rules of origin are comprehensive systems of substantive principles and administrative laws that collectively assist in determining the nationality of a traded good. These rules elucidate concrete tests of origin determination and regulatory mechanisms for certification and verification. The stringent twin test rule of origin determination applied in Indian FTAs has failed to control trade deflection and has led to underutilization of FTAs. An investigation of the product-specific rules applied on steel products revealed that India has been hesitant about using specific processing tests in its FTAs. Specifically, steel producers have also alleged cases of trade deflection of cheap Chinese stainless steel from Indonesia. They theorized that the cheap imports were dumped into the market using the ASEAN-India FTA route. We have recommended the use of specific processing tests of origin determination based on the European PEM Convention. In this way, industrial bodies and steel producers would be able to provide specialized knowledge about the nature of origin determination that best caters to their needs. India should also review its existing product-specific rules to harmonize a uniform set of tests for Chapter 72. In order to promote trade facilitation, the approved exporter system followed in the PEM Convention is recommended so that producers and exporters are able to issue their own proofs of origin without having to apply for a fresh certificate of origin.
Finally, when considering exiting as an option, we were faced with the issue of how to exit when there is no exit clause, and we found our solution in Article 56 and Article 59 of VCLT. Article 56 of VCLT provides unilateral termination of treaties of commercial nature, but we prefer Article 59 of the VCLT, which provides renegotiating a new agreement to replace the former. And finally, when drafting a model exit clause which suits India best, we concluded that India's current general approach of 6 months to a year period post-notice is ideal, subject to a few changes. First, India must maintain consistency in the time period, that is 12 months, and extend the legal effect of survival clauses to 20 years.